and a member of the Judicial Committee of the House of Lords of England.
Please, Giri, why don't you just give us the paper and then we gain the time instead of...
I'm doing. So this Lord says, we, in the discharge of his office, the advocate has a duty to his client who are here, a duty to his opponent who are there, a duty to the Honorable Court, a duty to himself, to myself, to ourselves, to respect this Honorable Noble Court, and a duty to the state, our country, the Republic of South Sudan. We are here for that. Your Lordship, the accused person prior to their arrest were subjected to politicized media campaign, outrages by ministers, politicians, and senior officers. In that campaign, explicit accusations were broadcast against them. The media broadcast against them to the public. This conduct amount to unlawful and prior conviction of our accused and a blatant violation of the constitutionality guarantee presumption of innocence, which is stipulated in Article 19, Clause 1 of our beautiful Constitution, read together with Section 6 of the Code of Criminal Procedure 2008, Laws of South Sudan. The accused is innocent until it is proved beyond reasonable doubt. And for our colleague, let me tell you from here, what is the meaning of beyond reasonable doubt?
Gary, please,
Let me conclude. Moreover,
you just try to conclude.
It is just only 3 lines. Moreover, the defense records...
Excuse me, Dr. Giri. You must know that Section 224 doesn't give you the right to respond. And we allow you to do that simply so that you enrich the procedures. Please try to summarize. Otherwise.
Thank you. I want to remind this Honorable Court that South Sudan belongs to common law and judges always make law in the absence of procedural fair. We have to do that to our country. Moreover, the defense records that the investigative authorities proceeded to arrest, interrogate unlawful search, and charge the accused person before their constitutional immunity had been duly lifted, and only thought to cure this defeat respectively. This violates the principle of legality, as a principle firmly recognized in our jurisprudence that what is built upon illegality remains invalid. It is null and void, ab initio, ad limine, from the beginning. Any such without due process of our Code of Criminal Procedure to our clients here are considered to be null and void, ab initio. Your Lordship, in addition, this case has placed the government in a position of embarrassment. It has been brought forward without proper official rights and without the request procedural foundation. This has left the public prosecution exposed to the extent that it risks withdrawal. This scenario mirrors a well-known precedent in which their late colleague, distinguished counsel, our late colleague, Charles Deng, our brilliant lawyer of this country, who passed on. He rejected to represent the government in the case of Asma Mahmoud, Mohamed Taha, and others versus government of Sudan in is published in the Sudan General Report 1986, where it was affirmed that the prosecution cannot sustain a prosecution in the absence of proper legal foundation. Honorable Justice of this Honorable Special Court, justice is neither proclaimed from political podiums nor declared in security offices. justice is dispensed in the courtroom, beautiful courtroom like this, such as this special court under the rule of law. And the rule of law, our professor, Albert Van Dicey, has come with his book about that.
I give you 2 minutes to finish your speech.
Thank you. Your Lordship, a matter of fundamental importance arises in this proceeding, namely the manner in which the prosecution intends to establish that accused person is standing before this special court are responsible for alleged crime, of which crime scenes in Nasir, in the Upper Nile State. It is undisputed fact that the said location is situated at a distance approximately 712 kilometers from the city of Juba, where all these are here, and Nasir is far. How they manage, they fly up to there and come. We don't have transport from Juba to Nasir. We don't have a road. How they manage to go there, the burden of proof lies on he who alleges to prove the case beyond reasonable doubt. Your Lordship, the accused person have been detained since March 2025 up to 21 of September 2025 in a clear violation of their constitutional right. A person arrested by the police as part of investigation may be held in detention for a period not exceeding 24 hours, and if not released on bond, to be produced in court according to provision of Article 19, Clause 4 of our beautiful Constitution of the Republic of South Sudan. Number 2, every person shall have the right of a fair and speedy trial, and justice shall not be delayed pursuant to provision of Article 122, Clause 5, Paragraph B of the Constitution, our Constitution, read together with the provision of Section 6A of the Code of Criminal Procedure Act 2009. Number 3, every accused person is presumed innocent until his or her guilt is proved beyond reasonable doubt in accordance with the provision of Article 19(1) of the Transitional Constitution 2011 as amended, read together with the provision of Section 6P of the Code of Criminal Procedure. Number 4, no punishment shall be inflicted upon any person exceeding the prescribed by the law in force at the time such offense was committed. The prosecution operating in speech is filed with political rhetoric and general description lacking material evidence, real evidence, and the legal element of alleged crime. In conclusion, because to conclude I must, we will respectfully invite your Honorable Special Court to render the 8 accused person not guilty of any crime. Thank you.
Okay. It's good to when a written written
Module.
Where is it? أشكر فضل.
لقد تقدم الأستاذ مولانا دين تشكيل ممثل الاتهام لتأجيل جلسة يوم غد الثلاثاء. إننا في اتفاق نعترض على الطلب الذي تقدم به ممثل الاتهام للآتي من أسباب. واحد، لقد ظل سيف الاتهام سلط على رقاب المتهمين منذ نهاية مارس 2025 إلى يومنا هذا، ولقد أخذ الاتهام بإجرار التحقيق والقبض والحجز لأكثر من 6 أشهر. إننا وفي اعتقادنا المتواضع لا نرى مبررا يستدعي تأجيل هذه الجلسة. علينا نلتزم المحكمة الموقرة رفض طلب الزميل والاستمرار وسماع المتحري.
Thank you, my lords. We all agree that this case has taken long, and in the interest of justice, it should move very fast. However, there are procedural requirements that we cannot jump.